Do you want to get a green card for your parents and bring them to the United States, but you don't know where to start? If you are a US citizen, the answer is yes. You can bring your parents to the US as lawful permanent residents. If you don't know me, my name is Remzi Kulen. I'm an immigration attorney with over 20 years of experience helping families reunite and build their lives in the US. Today, I'll walk you through every stage of the process step by step. Who can apply, which documents are required, how the process works, and the common misconceptions you should know about. Who can apply? To file for your parents' green cards, you must be a US citizen and at least 21 years old. One common misconception is that green card holders can apply for their parents. In reality, permanent residents cannot sponsor their parents. This right is only for US citizens. The good news is that parent petitions by US citizens are not subject to the annual visa caps. That means that they are not controlled by the visa bulletin, and once approved, the process generally moves much faster than the other family categories. Where should you file your forms? You must start by filing the I-130 with the USCIS. Whether you want to continue with the processing of the case within the US as an adjustment of status, or you would like to have your parents go to the interview at the US consulate, the first step is always an I-130. It is always filed with USCIS. If you want to continue the application within the US as an adjustment of status, your parent must currently hold a valid visa status. Choosing the right route between filing within the US or getting a visa appointment at the consulate depends on your parents' needs. Adjustment cases filed inside the US often finish faster than consular cases. However, if you filed inside the US, your parent generally should not leave the US until they receive advanced parole or their green card is approved. Otherwise, the case may be considered abandoned. Many parents don't love being unable to travel for a while, so be sure to explain to your parents they may not be able to leave the US until the travel permission is issued. So how does the process work? Everything starts with Form I-130, petition for alien relative. And remember, I-130 is the first step, whether you want to continue the application with a 485 within the US or whether you want to take the consular processing route and send your parents to the appointment at the US consulate to get their green cards. Also, a very important note here, you must file a separate petition for each parent. One for your mother and one for your father if you're filing for both. You cannot include your mother and your father in the same application. You have to pay separate fees. What are some of the documents to include with your I-130 application? Proof of your US citizenship. It could be a birth certificate, US passport, or naturalization certificate. You must also include your birth certificate to show the biological relationship to your parent. Any official documents showing name changes if applicable. If your parents are outside the US, meaning you chose consular processing, after the I-130 is approved, the case is transferred to the National Visa Center, which forwards it to the US consulate in your parent's country. The NVC will request immigrant visa application, Form DS-260, Affidavit of Support, Form I-864, civil documents including birth, marriage, and police certificates. Once documents are approved, each parent receives a separate interview date. These interviews are usually scheduled the same day, but these are separate interviews. If approved at the consulate, they enter the US on an immigrant visa and will soon receive their green cards by mail. There is always an interview if you choose the consular processing route. There is nothing to worry about this interview. The consulate officers will basically try to make sure the person for whom the application is being filed is the person on that day during the interview. They will verify documents. They will look if there's inadmissibility issues, and most of the time these interviews are very uneventful and results with the issuance of immigrant visa stamped in the passport. If your parents are already in the US, you will take the adjustment of status route. So let's say your parents are here in the US with a valid visa status, for example, tourist or student, they can apply for adjustment of status, Form 485, without leaving. You can actually file the I-130 and the I-485 together. This is called concurrent filing. And you should include Form I-864, Affidavit of Support, showing you will support your parent financially. Form I-693, USCIS medical exam. You may also apply for your parents for an EAD, which is a work permit, and advanced parole, which is a travel permit. I actually always recommend applying for an advanced parole and EAD. for various reasons. If you get an EAD first before the application is approved, you can get a social security number for your parents. If you can get the advanced parole before the green card is approved, you can have your parents travel internationally. Most of the time, parents don't like the feeling of being stuck in the US. They want to be able to travel. Without the advance, if they're in the US and you file the application within the US, if they don't have an advanced parole and if they leave the US, they will abandon their application. So it is important that you get an advanced parole for your parents just in case. We don't see a lot of interviews when US citizen children are filing a green card application for their parents. Of course, sometimes these cases also get an interview, but most of the time, these cases are approved without an interview. If there's an interview, your parents must go to the interview and answer the questions the officer asks them, usually on the form 485. If they don't know English, they can actually take a translator with them. English is not a requirement in these applications for your parents. So after the approval, their green cards are mailed to the address on file. How long do these applications take? It's a big question. Here's what we are currently seeing. I-130 approval, typically 8 to 14 months. If continuing at NVC, Consular Processing, add about 6 to 10 months for document review and interview. If the case proceeds within the US as an adjustment of status, the overall timeline is often about 8 to 14 months. If you include a work permit, EADs are often issued within 1 to 3 months. Travel permits can take about 8 to 12 months. Recently, we've seen combo cards issued, a single card that serves as both work and travel authorization, arriving for some clients in 1 to 3 months. It is important to note that within the US, you can file these applications concurrently, so that's why 8 to 14 months is the total time required to finish this case and get the green card. Whereas at the consular processing, you first need to get the I-130 approved, and then you can move on to the NVC and consular stages. This is the reason it takes about 18 to 24 months for these applications to be concluded at the consulate level. A big question, or should I say misconception, is I can also bring my sibling along with my parents. US citizens can actually petition for their siblings with a separate petition, but there's a big difference. Sibling petitions, F4 category, take much longer. The average wait is about 16 years. Yes, it is 16 years. You heard right. And just like with the parents, green card holders cannot petition for siblings. This is only for US citizens. Most of the time, it makes more sense for your parents to get the green card or wait out for their citizenship and then file a petition for their children, because these applications usually take less time than you filing for your sibling. Let me tell you a little bit about the common mistakes to avoid while filing these applications. Filing only one petition for both parents. Don't forget, each parent needs a separate I-130, separate 485, and separate NVC processing fees, and separate DS-260s if you're doing this through the consulate. Submitting weak financial evidence. The US citizen must meet financial requirements. If not, you will need a joint sponsor. So let's say your tax returns are not sufficient, you didn't work, you are still going to school, but you want to sponsor your parents. No problem. Even if you don't have the financial means, you can always find a joint sponsor to help you with the application. What about overstays? Is there no chance for overstays? If your parents enter the US legally, they can generally adjust status even if their visa status has expired. Those who did not enter legally or who have removal orders face a different situation and need legal guidance. In summary, to bring your parents to the US, you must be a US citizen and at least 21 years of age. You need to file a separate petition for each parent. You need to choose the route, consular versus adjustment, that best fits your needs, and follow each step carefully to avoid delays. This may be one of the most meaningful steps you take to reunite your family. To avoid mistakes, work with an experienced immigration attorney. If you found this video helpful, please like, subscribe, and turn on notifications for future updates. See you in the next video.